morning, good afternoon, good evening, depending on where you are in the world. Welcome to this new session of financial statements at the Peterson Institute. On behalf of the Institute, it's my pleasure to introduce it. I'm Nicolas Veron, and today we will discuss clearinghouses, also known as central counterparties or CCPs. This is a bit of a nerdy topic, but as everybody in the business knows, also a very critical one in terms of both the plumbing of the financial system or financial infrastructure, and also a number of disruptive crisis scenarios, because if that plumbing goes wrong, pretty much everything else goes wrong. So there is a dimension of financial stability in the discussion about clearing houses, which is always lurking behind the surface and justifies the attention they're receiving in the policy discussion. We have possibly the two best experts to discuss this today, Klaus Löber and Tracy Wingate. Klaus Löber is the chair of the Ccp Supervisory Committee, so the Committee to Supervise Central Counterparties, also known as Cftc, in the European Securities and Markets Authority, ESMA, which is the European umbrella securities regulator for the EU. Based in Paris, created a decade ago. And Klaus Löber studied law in Germany and France, in Mainz, Dijon, and Freiburg. He had an early career in law firms and also, importantly, at the Untitled, the privatization agency for the former Eastern German combinats in 1992. He was then at the Deutsche Bundesbank in the late 90s. He joined the European Central Bank in 1998, and he stayed there until last year. So for more than 20 years at the ECB, with two intermezzos, one in 2004-2005 at the European Commission in what is now DG FISMA, and one for a slightly longer period, 2012 to 2016, at the Bank for International Settlements in Basel, where he was the Secretary General of the Committee on, what is now known the Committee on Payments and Market Infrastructure, formerly CPSS, and I think Klaus was instrumental in the very long overdue change of name. So at the European Central Bank, Klaus Löber has held a number of positions, including head of the Oversight Division in charge of financial market infrastructures, payments instruments, and schemes. So there was a kind of natural transition from there to his current role at ESMA. The CCP Supervisory Committee, which he chairs at ESMA, was created recently on the basis of the revision of the European Market Infrastructure Regulation, EMIR. So it's a new supervisory function for ESMA, and the CCP Supervisory Committee is a kind of agency within an agency within ESMA, which Klaus is the first leader of, and there are two other members of the committee. So he will probably tell us about this organization. Tracy Wingate is the Chief of Staff for the Investment Company Institute, ICI. ICI is one of the oldest industry bodies, financial industry bodies in the US. It represents the fund and asset management industry. She studied at Tulane University and University of Virginia, also in law. She has held various positions in law firms also, including at the Washington office of Arnold and Porter, focusing on product liability litigation. And then she had a 15-year career, a little bit more, 2005 to 2021, actually, this year, at the Cftc, the Commodities Futures Trading Commission, which is, in a way, one of the counterparts of ESMA in the US system, and the regulatory and supervisory agencies for derivatives and futures exchanges in the US. So she was obviously Klaus Löber's counterpart in a number of transatlantic and international discussion formats. And indeed, she was also the European Commission's counterpart, and she played a leading role in negotiating the European Commission equivalence agreement with the Cftc for US-based clearinghouses, and he worked with ESMA to secure recognition of these US-based clearinghouses, allowing them to operate in the European Union. Obviously, there's a background to this discussion, which is a discussion on not US-based, but UK-based clearinghouses, which is very active now, but this is not the single focus of our discussion today. We will take a broader view, transatlantic and global, even so I'm sure we'll have questions from the audience on what's happening between the EU and the UK. With that, Klaus, over to you.
Many thanks, Nicola, and hello to everybody. It's a pleasure for me to join, and to join particular session with Nicola and Tracy, which is always very good fun. And I'm also grateful to have been invited to speak on a topic which seems to be a recurrent feature in my career. Actually, if I walk down memory lane quite a bit in my times as a very young lawyer, and I keep forgetting about this, one of the early dossiers that ended on my desk was labeled Deutsche Terminbörse. At that time, I had no idea what it was, but it was about to be changed in something called Eurex. So I had a very hard learning curve there to first understand what these kind of creatures are about and how you actually go about them. But
and if you allow me, Eurex, of course, is the clearinghouse of the Deutsche Börse group now, so one of the key participants in this market now in the EU.
Thanks, Nicola. I appreciate that I already get too nerdy by using certain terms. I will try to avoid that. However, I must say the central counterparties and the clearinghouse domain has been a kind of recurrent feature throughout my career. And I must still remember very closely because when the financial crisis hit, in particular the Lehman default, I was actually in a very nice international conference, and I got a call from the ECB at that time, insinuating that not only it would be a good idea if I come home now, but also that I don't go home, but immediately join the office. And since then, the CCP questions have been, of course, recurring. As we know, one of the key outcomes of the financial crisis was the uniform desire of the international standard-setting bodies to enhance the role of central clearing for reasons of mitigating the risks that may result from OTC derivatives. And since then, constantly the role, the market share of central counterparties has increased, as has the international dimension. And that is, of course, one of the reasons why we have been convening here for this particular feature. I want to touch in my introductory part a bit on these international aspects. And again, of course, with my current background, I can give a bit of color because my current role as CCP Supervisory Committee Chair has a very dominant angle which looks at the cross-jurisdictional implications of central counterparties. But looking at the international dimension, perhaps to go one step back and to look at the work following up the international consensus to enhance central clearing. There was quite a bit of work on the international sphere, in particular by the Committee on Payments and Market Infrastructures and IOSCO, the International Organization for Securities Regulators, to enhance the standards for safety and efficiency of central counterparties. Evidently, the more risk you concentrate in these bodies, the higher the need to have a robust framework to address those risks. This resulted in the principles for FMIs, the PFMIs, which I had the pleasure to conclude during my heading the Secretariat, and also quite a bit of subsequent guidance enhancing on some particular aspects like cyber resilience or recovery and resolution, which are, of course, another core element of the total package. But what is interesting is already in the first part of the PFMIs, there is a particular sector that looks at specifically the cross-border implications. Across the principles, you find references for CCPs to understand implications, both the risk they pose to their participants, which can be from multiple jurisdictions, but also the risk that those participants pose to them. And likewise, there's increasingly interdependencies between market infrastructures, CCPs and other market infrastructures, or linkages between CCPs. And again, that is an aspect which requires a cross-jurisdictional perspective. To that end, the PFMIs actually contain a particular recommendation for authorities, so-called Responsibility E, which outlines that it is the best practice for authorities to closely cooperate and to establish arrangements that support these kind of cooperations when there is a cross-border dimension to the operation of infrastructures and CCPs in particular. On the side of the EU, the response to the PFMIs and these developments was a piece of legislation with a nice name, EMIR, the European Market Infrastructure Regulation, which implemented the standards and at the same time entrusted ESMA, the securities market authorities, with particular functions. And that is a very particular European thing. You have the national competent authorities, which have a primary responsibility in a number of issues, and you have a certain centralization of functions with European bodies like ESMA to coordinate, to provide supervisory convergence, in some instances also to exercise direct powers. The original EMIR legislation was picking up the risk from CCPs by providing a framework to ensure that there's enhanced supervisory convergence across national authorities and establishing colleges, so-called EMIR colleges, bringing together a multitude of relevant authorities that have an interest in the smooth operation of a particular CCP, whether it is securities regulators, whether it is bank supervisors or central banks of issue. And that has been in place already for quite some time. However, there was also the recognition that there is a dimension beyond the EU. And to that end, EMIR entrusted ESMA with the authority to recognize third country CCPs under certain constellations, provided that there is a cooperation with the home authority of the CCP and provided that the CCP itself is meeting a number of requirements. That dates back to 2012, but of course since then the industry has evolved, and also the role of CCPs has considerably increased. And like for any good piece of legislation, you occasionally review, and there is a major review that has the strange acronym EMIR 2.2. Don't ask me now to differentiate between 2.1, 2.2. The main part of this legislation is actually to further enhance the powers entrusted to ESMA in two respects. First, to significantly increase the degree of the role of ESMA in supervisory convergence. ESMA participates in all EU CCP colleges. It has a role to review and to provide decision and opinion on supervisory actions and college decisions. And it also has a role in validating model changes of CCPs. This is centralized for the EU CCPs. At the same time, ESMA has also been entrusted with increased powers towards third country CCPs in recognition that there may be quite a difference between the roles of CCPs that can be played when it comes to third country interactions. The degree of foreign participation in or EU participation of EU clearing members or EU clients in a third country CCP can differ significantly. The usage of EU denominated products in a third country CCP can differ widely, and as can the implications, the risk implications of a third country CCP for the EU. As a consequence, there has been an establishment of a classification structure with two tiers of different systemic importance to the EU. Those CCPs that do create certain risks potentially, but are not of a systemic dimension for the EU financial markets are labeled Tier 1. Those who are considered to be of systemic importance are labeled Tier 2. Before I spend a second on the treatment of those, which again ties in nicely with our cross-border dimension that we are having in this dossier, let me just say one word about how this is being organized. Because in order to have a centralized body that is actually taking these coordination activities, inside ESMA, there was the establishment of, as Nicola already mentioned, a specific body, the Ccp Supervising Committee, who has been entrusted with specific powers to actually undertake both those activities as regards EU CCPs, but also to undertake the responsibilities in respect of third country CCPs. This committee consists of an interesting composition. Normally in the EU, you always have a representation of all member states, or at least of an authority of each member state. In this case, apart from myself and two independent members, which are meant to provide an independent view on these matters as well, they're representatives from those national authorities who actually oversee a CCP in their jurisdiction. These are currently 11 authorities for 13 EU CCPs. In addition, for certain topics, the central banks of issue of relevant EU currencies participate in this committee. So that is a quite unusual setup, but one which allows to bring together the relevant expertise and perspectives for these matters. So very briefly, and I promised Nicola not to take too much time for the introduction, just to flag two issues in respect of the third country cross-border issues. First, we always have taken in ESMA a risk-driven approach to the recognition of third country CCPs. And currently there are about, I think it's more than 35 now, third country CCPs that are recognized by ESMA and therefore authorized to offer services to EU clearing members. That is a significant number. And that by itself provides a very good overview also for ESMA to consider not just the EU risk dimension, but the global risk profile of CCPs. That is a quite unique situation, I must say, also compared to discussions we occasionally have with other authorities who of course also have some cross-border perspective, but perhaps not such a comprehensive picture. And within this framework, there's also the differentiation that I mentioned. For the tier 1 CCPs, what we basically do is we review a CCP and its specific setup and risk profile. We provide the recognition, and then we monitor the CCPs. We are not having direct supervisory powers in respect of these CCPs, but we monitor, and we are in a close exchange of information also with the home authorities under MOUs that we have established. That is something which is currently being implemented, the move from the old EMIR framework to the new EMIR 2.2, which forces us to review and tier all those 30 plus CCPs, and to also modify the existing MOUs to take account of the new framework. Quite a comprehensive task. But what has a much higher degree of attention in the public discourse, of course, is the situation as regards so-called tier 2 CCPs. We are asked to consider and determine whether specific CCPs of such systemic importance that a mere reliance on deference is not sufficient. And this determination resulted in 2 CCPs to qualify as what is called tier 2. This is LCH Limited and Ice Clear Europe. Both are located in London. And of course, from an EU market perspective, those 2 CCPs have a significant role in some product areas, a dominant role for the EU markets, for the EU market participants, and for euro-denominated products. And in view of this particularity, EMIR is entrusting ESMA, the Supervisory Committee, with direct supervisory powers. That is quite unique, and something, of course, which to implement requires quite a degree of calibration. These direct supervisory powers exist on top on the powers of the Bank of England as home supervisor of those tier 2 CCPs. We are, of course, having established a very close working relationship with Bank of England. We have an enhanced MOU with them. We exchange, we coordinate quite intensively, but the setup allows us to independently operate supervisory activities, to conduct reviews, to conduct analysis, and also, where necessary, take enforcement actions. And that is, of course, the direct recognition of these enhanced systemic relevance for the EU. Again, this is something which has been established and is operative since the beginning of the year, and we are still further enhancing the procedures and processes. There's one element to alleviate perhaps some frictions that some people may see. EMIR foresees also a process called comparable compliance, where to avoid an undue burden on the CCPs concerned that they have to comply with two potentially duplicating frameworks, they could apply for comparable compliance recognition, where they would only have to comply with the UK framework. However, I want to stress this is a framework which would not alter their systemic importance for the EU. So from an ESMA, from a supervisory committee perspective, even under comparable compliance, we would still consider the necessity to have the full information set, both on the CCP itself, but also on the supervisory actions taken in respect of those CCPs, to be in a position to fully understand the risk implications and also to take responsive actions if needed due to certain developments. I stop short here, Nicola, and I guess there will be some questions in particular when it comes to questions, what happens if actually this setup is not sufficient? And there is a potential discussion currently going on, but perhaps this is something we can touch on in the discussion. So let me stop short here, Nicola.
Thanks for signposting the lurking equivalence issue. This is a very nerdy topic, so let me just summarize a couple of things I understand from what you said, and sorry if that sounds dumb. But so you have here, the tier 1 CCPs are foreign CCPs. So for example, in Singapore, New York, India, or in London, and you recognize them, you monitor them, you don't supervise them. So tier 2 CCPs are just LCH and ICE in London. LCH is part of the London Stock Exchange Group, right? And ICE is part of the ICE Group, which is headquartered in Atlanta, or also includes the New York Stock Exchange. So these are the two big ones, tier 2, and these you supervise, but you're not the only supervisor, because the Bank of England is also a supervisor, and actually, as we may hear now, the Cftc is one as well. And that has been in place since January 1st, right? You have started supervising them, so you are already in action in that role in the new setup. But the missing link, of course, are CCPs or clearinghouses inside the EU, like we mentioned, Eurex or others. Can you say a word about these? So what role do you have vis-a-vis those onshore CCPs for the EU?
Perhaps I was a bit shorthand on this, Nicola, apologies. So yes, in fact, for those which are directly subject to the EMIR regime, as they were in the past, the primary supervisory responsibility remains with the Home Authority. So the BaFin for Eurex, or let's say the French AMF for LCHSA, the CCP located in Paris. However, the new design, including the Supervisory Committee, entails that there is a very close alignment of the supervisory approaches, not only due to the similar set of regulations, but also due to the application. We basically review each and every relevant decision in respect of those CCPs, including college opinions, and we, in the Supervisory Committee, take decisions on those which feed into the national supervisory process. This has led already to a much stronger alignment of the actual conduct of supervision, and it also allows us to discuss issues that are either relevant within a single EU CCP or common patterns across various EU CCPs in the Supervisory Committee.
So we may come back to this because it's indeed a kind of puzzling architecture, but now let's cross the Atlantic and over to you, Tracy.
Great. Thank you, Nicholas, and thank you, Klaus, for that very comprehensive introduction. So first, Nicholas, thank you for asking me to participate in this discussion. Before I start, I have my own housekeeping, my disclaimer. So the views I express today are my own and do not reflect the views of my current employer, the Investment Company Institute, or that of my former employer, which
Are
is
you a lawyer?
the CFTC. And as such, these are my own indeed views. So I echo a lot of what Klaus has said in terms of the construct of both the European and the CFTC CCP regimes. There are definitely similarities. Before I go into sort of a broader description of the CFTC regime, I think it's important to point out that the CFTC regime, when it comes to CCPs, the regulation and supervision of CCPs happened organically. And it started actually with LCH back in 2001, really prior to the CFTC having its own comprehensive regulatory regime for foreign CCPs, or in European parlance, third country CCPs. So the CFTC regime has been tweaked over the years and has not had the benefit that the European construct has had, which is effectively starting from scratch, to build their regime. So with respect to the CFTC, the supervisory approach with respect to foreign CCPs, third country CCPs, what have you, is based on supervisory cooperation. And what I mean by that is it's very much grounded in deference and international comity. And in this regard, the CFTC has codified 3 different registration categories. And these categories effectively represent the strata of how much exposure U.S. market participants have in these foreign CCPs. So in other words, the greater the exposure that U.S. market participants have, let's say in an EU CCP, the greater likelihood it is that the CFTC's engagement with the home regulator of that EU CCP will be stronger. And in some cases, that does mean direct supervision of U.S. clearing activity. And what I mean by that is the activity of U.S. market participants and their clearing activity within that EU or foreign CCP. So the 3 categories. The first category is an exempt CCP. And in that construct, the CCP can clear for U.S. persons, but only proprietary swaps positions. So they cannot clear for U.S. customers or in EU parlance, EU clients. And in that category, the CCP is required by the CFTC to have comparable and comprehensive regulatory regime and be compliant with the PFMI. In addition, the CCP has
and the PFMI, once again, sorry to interrupt, is Principles for Financial Market Infrastructures that Klaus held when he was in Basel at the Committee on Market, on Payments and Market Infrastructure. I got it.
Yeah, and I will level set there by saying that much of what our audience will hear that is similar in the CFTC construct and the European construct is because of the existence of the PFMI, the Principles for Financial Market Infrastructures. They really set the baseline on international risk management standards for clearinghouses, particularly systemically important clearinghouses. And without that, the degree of harmonization that has occurred, in particular between the EU and the CFTC, and to some degree the SEC, simply could not have happened. So the PFMI are a really critical component to all of this. And so going back to this registration category, provided that the third country CCP it is compliant with the PFMI and is supervised under a comprehensive CCP regime, then that foreign CCP will have some reporting requirements to the CFTC, but otherwise the CFTC defers completely in the oversight, the regulation, the day-to-day operations of that CCP. So completely hands-off, effectively. The second category is a relatively new category. That's registration with alternative compliance. That category is for those foreign CCPs that do not pose a substantial risk to the US financial system. And what I mean by that is that the US market, clearing market participant exposure is under a set threshold. It's 20%. And provided that they are under that threshold, the CFTC provides a hands-off approach that is, in fact, a little bit more robust than the exempt version. So the foreign CCP will have still has to provide some meet some US customer segregation requirements for US clearing participants. There's still going to be reporting and notice requirements. But otherwise, the foreign CCP can meet it's called core CCP principles. These are sort of a fundamental basis to the CFTC-CCP regime. They can meet these principles by effectively following their very own home country regulators' rules. And provided they meet them, again, it's a hands-off approach day to day with respect to the oversight, the resilience, and the supervision of the CCP. The third category is what I would call full-on registration. And in this context, a foreign CCP is subject to the full panoply of CFTC rules and regulations. However, the foreign CCP can meet many, if not all, but many of these requirements if the CCP is in a regulatory regime that is aligned with the CFTC regime. And the example would be EMIR. So for example, a European CCP such as Eurex, is able to meet the CFTC, many of the CFTC requirements by meeting the very requirements set forth in EMIR. And of course, under full registration, the CFTC does have oversight over US clearing activity within the European or the foreign CCP. There are pretty robust reporting and notice requirements, and the CFTC has the authority to engage in examinations, which in EU parlance is inspections. And the last thing I will say on that, because I know, Nicholas, I might have gone over my 5 minutes here, is that the overlay to this construct, and this is what I think is really important here, and I think is important to our audience, is that the way that CFTC engages with foreign regulators is based on certain pillars, right? And one of those pillars is that supervisory cooperation is critically important, and establishing that communication during peacetime is essential in order to be able to carry out whatever exercises might be necessary in stressed markets or during crisis moments. The second is that any direct supervision by the CFTC as relates to a foreign CCP, must be narrowly tailored and, meet satisfy and meet the exact risk that the CCP presents to the U.S. Market. And the third, I would say, is that there is an importance stressed on the role of the primary CCP regulator. And what I mean here is the home country regulator of the foreign CCP, a recognition that there are primary duties in terms of the overall well-being of the CCP, resilience, the day-to-day operations, the risk management. That is the role of the primary CCP, even when there is a foreign CCP has full registration with the CFTC. The CFTC is aware of the role of that primary regulator and seeks to coordinate and cooperate with that regulator in the supervision of that CCP. So with that, I will stop.
Thank you so much. And I think it's really important for us, certainly for me, to understand those categories. So full-on registration is, roughly speaking, the equivalent of Tier 2 in the EU context, right? Yeah. And Klaus told us that there are two designated or determined Tier 2 CCPs right now from the EU perspective, so outside of the EU, but considered important enough for EU stability. And these are LCH in London and ICE in London as well. Can you give us a sense of which CCPs outside of the US are full registered with the CFTC?
Sure. So very similarly, LCH Limited in London and ICE Europe in London, LCH SA in Paris, as well as Eurex in Frankfurt.
So there's none in Asia?
There was one in Asia. In the past 2 years, it's ramped down its activities. So it's either dormant right now or it's withdrawn its registration.
Can you tell us who that was, or is that secret?
SGX. It's all publicly available on our website, on the CFTC website.
You're forgiven for that slip of the tongue. Okay, so that sets the scene, I think, in a very comprehensive way. Let me directly shift to questions from the audience, and I will start with a question from Ted Truman, who used to be at the Peterson Institute and is now at Harvard. It sounds like the constructs and cooperation between US and EU regulators in this are very robust. I wonder about other major jurisdictions, such as, of course, China, but also Japan and India. Can you give us a little bit of a sense of that? Maybe Tracy first and then Klaus?
Sure. So it's very interesting because in the CFTC world, you do have JSCC that is an exempt DCO.
So that's Japan?
Yes, that is Japan. And outside of that, there are no other Asian CCPs that have any form of registration with the CFTC right now. Part of the issue that you will see in Japan and China is the localization requirements and, frankly, the vast amount of money it takes for clearing members to set up shop in these jurisdictions and to be able to clear for, in my case, or in the CFTC case, US market participants. And that's a setback. And that's why, frankly, you don't see more engagement between the CFTC and these jurisdictions.
So just to understand, Japan has what Europeans would call a location policy. They ask folks who want to clear trades in yen or, for that matter, in other currencies in Japan to have a local operation. And therefore, that clearing is not considered US clearing because it's done through the local entity of those groups, even if the group has its home registration in the US if it's a big US investment bank, for example.
Something along those lines. It's more prevalent actually in China, I would say. I'm reminded that the Shanghai clearing house, I believe, also has exempt status as well. And I do believe that there is an Indian clearinghouse that escapes my name right now that also has the exempt status. But effectively, you're looking at the same thing, which is that in order to clear for US customers, there are certain requirements that are very difficult for these clearinghouses to meet. Some of them relate to customer segregation rules. In the US, we have something called LSOC, legally separated but commingled, operationally commingled. That has to do, I know this is weedy, that has to do with the US bankruptcy law. So
I always when I learn a new acronym, I didn't know this one.
So one issue is respect with the ability of these clearinghouses to put forward a regime that aligns with LSAC. The second is, yes, location policy issues do play a role in terms of the difficulty that future commission merchants, which are the broker dealers in the Cftc world that are the, transact between the US client, the customer, and the clearinghouse. They're the intermediary, and they need to be able to register. They need to, in the foreign jurisdiction, they need to be able to set up their business, and it needs to economically make sense. And the locality requirements really do, interfere with that ability. So that's what we're seeing over there.
Klaus, on these extra transatlantic dimensions.
Okay, not much to add to what Tracy has said, in particular for the Asian jurisdictions. Perhaps only one element here where I usually make a bit difference. I think terms such as location requirements are not very helpful because they are shorthand for a wide variety of different concepts and different regulatory intentions. And that may on occasion be misleading. It can be, as Tracy has been describing, rather cumbersome operational procedures that may provide a kind of deterrent to provide service from abroad. There may be other reasons, and I usually would be very diligent in disentangle objectives that may be driven from industry policy or competition perspectives and those which are driven by financial stability considerations. Which
basically, when we say location policy, your response is to say, well, which location policy? What do you mean, right?
What is the rationale? What is the purpose of specific rules that may exist? But going back more specifically to your question, just to add one additional color here, and that is, of course, given that the currently applicable regime in the UK is still EMIR, they also have the regime that would allow them to tier foreign CCPs. And this has not happened so far, but it will be interesting to see what positions the UK takes here. Again, we have a very interesting situation here as compared to the overall convergence, which are very much subscribed, that Tracy has been mentioning. The PFMIs have been really helpful to have a high degree of regulatory convergence.
So just to understand, the Bank of England at this point has not determined any third country CCP to be tier 2 from the UK perspective?
It has
Correct.
not conducted a tiering exercise, yes.
Yes. Yes.
Okay. Thank you. Sorry for interruption. Go ahead, Klaus.
Perfectly fair question. But of course, usually you have a situation internationally where rules between different jurisdictions align more and more. We have the intriguing situation in the UK that they have left the EU with the express intent to be able to diverge regulatory. And that is, of course, something which requires a particular attention when it comes to looking at issues such as equivalence of rules or of comparable compliance, because you need to be attentive of this regulatory intent and to make sure that you are actually seeing those divergences as they may arise and are able to respond. And that is a bit unusual to what we see in the transatlantic dimension, where I must say, also, as you have been seeing from Tracy's description, we have a very high degree of similarity in approaches, and that has allowed to have a very robust cooperation with the Cftc and ESMA.
So just back to Asia, that means that the JSCC in Japan, Shanghai Clearinghouse, they're all tier 1 for right?
Right.
Which means that you recognize and monitor them. How does it feel to monitor the Shanghai Clearinghouse?
Well, Shanghai.
I'd like to know the answer to that one too.
Yeah, and I should be precise here. Shanghai is not yet part of the tiered CCPs because there is no equivalence decision of the European Commission yet. So to have recognition or monitoring and designation as a tier 1 CCP, you need an equivalence decision for the jurisdiction, right? Correct. That is a precondition, and the Chinese regulatory framework has not yet been determined by the European Commission as whether it is equivalent or not. This is a pending decision. So from that perspective, I can't give you the answer for China, but for the cases of the Japanese or Indian CCPs that Tracy was alluding to, they are qualified. Well, we are now in the process of conducting the EMIR 2.0 tiering. So let me not prejudge the outcome, but again,
I almost thought I had a scoop. Okay, so we inevitably come to the UK and to the advice you need to give to the Commission on equivalence and also location requirements. So can you give us a sense of the process on this, even so I know that you won't give us a sense of your eventual decision?
Fair point. And happy to do. And actually, that is a particularity that I should have probably highlighting a bit more clearly in my original presentation. The situation with the UK CCPs, both the 2 tier 2 ones, but also LME, which is qualified as a tier 1, the London Metal Exchange, they have a temporary status. Temporary in a way that following Brexit taking effect, the European Commission has granted temporary equivalence for a period of 18 months. And likewise, ESMA has granted temporary recognition for the same period.
So until the middle of 2022, right?
And June of next year. So time is already flying. We are already 6 months into this 18 months process. The reason for this temporary nature was primarily to see A, the effectiveness of the arrangements, but B, even more important, to get a better understanding of the degree of systemicity of the tier 2 CCPs. And in respect of those two, there's a specific mandate to ESMA to review the existing recognition, in particular, look at whether the 2 CCPs or some of their services create such substantive systemic importance. And now we can have an intriguing economic discussion about what is substantive systemic importance as opposed to systemic importance, that the existing EMIR framework is not sufficient to mitigate the risk for the EU financial system. And the consequence of this could be that ESMA could recommend to the European Commission not to recognize one of those CCPs or some of its services under EMIR. That would mean those CCPs would no longer be able to serve EU clearing members and offer services to them.
So that would be a decision by the European Commission on the basis of advice they would receive in particular from you, right?
Correct. And that is now coming to the process. It is an extremely complex kind of analysis, as you will appreciate. And it has quite a number of elements that are being prescribed already by law that we need to take into account. And we are looking at various dimensions of potential risks and the sizes. Risk looking at the credit exposures, liquidity exposures for EU clearing members, the individual capacities of EU clearing members to compensate for losses in this regard, the buffer capacities of individual clearing members, or the jurisdictions, the EU as a whole. There are issues related to non-default related losses. If there is a problem in one of the two CCPs, that may spill over and create in turn problems for the EU clearing members, but also issues that are of a wider dimension, that is just perhaps the unavailability of a UK Tier 2 CCP for operational risk reasons. Again, there are a number of scenarios that we need to look at, and ultimately, both for a situation where there is a crisis situation, there's a situation where a CCP may actually run into a recovery or even resolution scenario. What is the existing framework? Does it allow to address those risks? Does it allow the EU, ESMA, the Commission to preserve the financial stability in the European Union? That is the first part of the exercise that we are asked to do. And this is combined, and that is something for people knowing European process quite familiar, with a cost-benefit analysis. So we will also have to look at a variety of elements that may entail the cost dimension of a potential consequence not to recognize. What does it mean for EU clearing members? What does it mean for EU clients? What does it mean for the EU central banks, for example? The impact on currencies, the impact on EU collateral, a number of areas that we need to look at in terms of consequence of such a decision. What are the benefits of this? And here there are some immediate consequences, but also some less tangible ones, like the strengthening of capital markets union may come into play. But what we are currently doing is we have been working on a methodology to conduct this assessment. And the assessment itself will consist of a data collection exercise, which we have engaged with a wide range of stakeholders, both the UK, CCPs, and stakeholders inside the European Union. This will lead to an assessment based on the data and input that we will collect from, as I said, a wide array of stakeholders. We actually are going to embark in the course of this summer on a number of public hearings as well. Reach out to different groups of stakeholders to get their views, to get their feelings, to get their estimation on the risks, the benefits of a particular situation now or in the future. And the end result will be, as I said, the recommendation.
So you will make a recommendation for each of the CCPs, for LCH and ICE Europe separately?
It is, in terms of process, probably a single. And again, depending on the outcome of the assessment, it may be also possible that we don't give a recommendation at all. Because if we don't have a finding that raises a particular risk, we would not need to give a recommendation. So it's an open-ended process. And the only element is we need to conclude our assessment by the end of this year, because if there were a need to take certain actions, it requires implementation action.
So how does that connect with the equivalence process? I guess the Commission is also asking for your advice on whether to renew equivalence.
That is the next step. Once we have, if we are to give a recommendation, submitted our views to the Commission, they will review. They will then, on the basis of this, form a position whether there's a need to review the equivalence decisions. And depending on this determination, in turn, we will have to act on the recognition as well. So it's a quite protracted process. Unfortunately, the procedural aspects take quite a bit of time, which is impacting on the duration of the assessment. That's why we are currently working at high speed in the Supervisory Committee and ESMA on the various elements.
So you look at, basically, if I summarize it, and sorry for being dumb again, you look at the individual CCPs first, so LCH Limited, ICE Clear Europe, and LME Clear, and then that will inform the process on equivalence renewal or lack thereof next year, right?
LME is not part of this. We are only asked to look at the two tier 2.
Oh, okay, sorry. My bad on LME.
No, you're correct. We are looking at the CCPs individually, but also this is important to realize. We do not need to look at a CCP holistically. We can also look at individual services. So we would be theoretically able to differentiate between different services provided by a CCP. For example, looking only at interest rate swaps as opposed to credit default swaps or whatever is within the product range of a particular CCP.
So interest rate is swap clear, right? It was in LCH. Which is a pretty big operation. Yes. One thing I should have mentioned at the beginning, and I'm ashamed I didn't, but I hope it's not too late, is that I should have referred to my own involvement into infrastructure space as a non-executive independent director of the trade repository arm of DTCC, which I've been through since 2013. DTCC is a very big player in the clearing space in the US. They're not involved at all in the clearing of derivatives, and they're not involved in clearing in Europe right now. So that doesn't create a conflict for me here, I hope. But nevertheless, I should have disclosed it early on. Tracy, do you have any advice for Klaus when he has all these difficult determinations to make?
I do. I would say I don't envy the position that Klaus is in. You know, there's no doubt there are very aggressive political forces that are seeking to relocate euro-denominated clearing onto the continent. I mean, that it's everywhere. You know, it's widely known that that's the case. ESMA is in a very difficult position. You know, even if they were to make a recommendation to de-recognize SwapClear, let's say, so just a silo of the clearing service that holds, you know, I think it's upwards of 90% of all euro-denominated clearing in the world happens in that clearing service.
So that's clear again, right?
Yes, that is SwapClear. You know, it presents operational challenges that, frankly, nothing like this has ever been done before in terms of migrating this, you know.
So is that more, would that be more complicated than the LIBOR transition?
It would be similar in terms of what would be involved. I mean, certainly there are extreme operational challenges. There are financial stability risk implications. There will be market fragmentation. Ultimately, EU market participants will face increased costs. There will, I mean, part of this is that while 90% of euro-denominated clearing happens within LCH's SwapClear, only about 25% of that has an EU nexus. So if ESMA recommends pulling out that 25% and let's just say bringing it onto the continent to, let's say, Eurex, what happens is that Eurex only has 25% liquidity. The 75% of that 90 is still in London. And that's still where the majority of IRS contracts throughout the world will be cleared. Exactly. So what happens is, yes, the EU gets a chunk of euro-denominated clearing back on the continent, but it doesn't get an LCH lookalike. It doesn't get that liquidity. Right? It gets something completely different.
Basically, your advice to Klaus is don't do it. It's stupid.
I wouldn't say it's stupid, but I think, and I know that Klaus knows this already. I know Klaus from, you know, way back when he did work at.
Yeah.
Let me perhaps, Nicola, if I may very briefly react.
Yes, but it's a difficult task.
It is undeniable a difficult task. And I also appreciate, as has been identified by both of you, there's a strong political undercurrent to this. The element where I draw comfort on is the mandate given to ESMA is a technical one. And there are other work streams that look at other aspects. The Commission has a different mandate. The Commission, for example, looks at strengthening the EU financial markets overall. They look at obstacles and incentives to enhancing clearing in the EU, which is within their right. We have a very targeted task, which is to look purely at the financial stability implications of the provision of offshore services in the clearing domain. And what is different from other cross-border constellations, as came out very clearly, the degree of concentration of derivatives with an EU nexus in an offshore market here is significantly higher than in other constellation that you find. And I would contend all of the points that you raise are perfectly legitimate, and we will look at all of this together, and it's an open exercise. There are elements that you need to differentiate. There are certainly costs. There are transition costs. There are long-term costs. That's what we will have to look at very carefully. What does it imply as well? But only after we have first identified whether there is a substantial systemic risk. That is the starting point. And the objective, if we identify this, is to find ways to mitigate that risk. It's not about gaining a certain percentage of a certain market. It is to minimize and better control those risks. And that's what the exercise is about.
So unfortunately, we're at the hour, so we won't have time to continue that conversation, on which I have many more questions. Let me mention a question from Jack Schickler. The Dutch Financial Stability Committee yesterday said forcing UK clearing business to move to the EU would endanger financial stability. Do you agree? So I take it from your last point that this is the question you will try to answer in your recommendation. So it's premature to ask you for an answer on this one. We have a fascinating question from Elliot Posner. We're all taught that immediately after crisis, we get stringent regulations, and once politicians aren't paying attention, industry lobbies succeed in watering down the reforms. It seems the regulation of CCPs have defied this pattern thus far. So I just mentioned the point. We won't be able to address your reactions to it for lack of time. But I do want to thank both of you very fully for taking part in that conversation. This is, as I guess everybody is aware of, a sensitive issue, and especially for Klaus, who is in that hot seat, it's actually important, I think, and also brave to come and talk in public about it. So thank you very much, Klaus, for that. Thank you, Tracy, for also commenting on it. The next session of the series will be on July the 14th, with apologies to my French compatriots who are supposed to celebrate the revolution that day. We will host Isabel Schnabel of the European Central Bank, talking about the challenges of the current low interest rate era. And in the meantime, again, many thanks to Klaus and Tracy, and have a great rest of your day. And welcome, hopefully, back soon in the different series of events at the Peterson Institute.
Thank you so much.